Welcome back to Winning Isn't Easy. Sometimes court cases read like mystery stories. Sometimes they read like fairy tales, and other times they read like horror stories. I'm going to tell you the horror story of how one court upheld UNUM's claim denial in a mold toxicity claim under the mental nervous policy limitations. Now, one of the many weapons the disability carriers like UNUM will use to justify a claims denial after the payment of 2 years of long-term disability benefits is the mental nervous policy limitation. It's a weapon that UNUM uses in cases where the policyholder has both a physical and a mental basis for their continuing disability. So let's learn the tricks and trade techniques of UNUM and how they use this mental nervous condition to deny benefits to a policyholder with mold toxicity. Now, I read all of the new ERISA disability cases every week because I think it's a great way to learn the games the disability carriers play and how the courts react. And this case is not one that has a happy ending at all. Let me tell you the story of Ms. McCook. She worked as an account manager for Ubisoft, selling video games to retailers. She became disabled as a result of mold toxicity. So she had environmental sensitivity, cognitive impairment, and depression and anxiety. Her physicians diagnosed her with an unspecified neurocognitive disorder and an adjustment disorder with mixed anxiety and a depressed mood. Her UNUM disability policy provided that after the payment of benefits for 24 months, her benefits would be limited, and that was basically going to be all that she would be entitled to. One of the most important provisions in the policy is the definition of mental disorder. And we've alluded to that in other episodes. In this particular case, the definition of mental disorder was a psychiatric or psychological condition classified in the Diagnostic and Statistical Manual of Health Disorders, published by the American Psychiatric Association, most current as of the start of the disability. Such disorders include, but are not limited to, psychotic, emotional, or behavioral disorders. The policy went on to provide that UNUM couldn't apply the mental disorder limitation if dementia was the result of a stroke, trauma, viral infection, Alzheimer's disease, or other conditions not listed, which are not usually treated by mental health providers or qualified providers using psychotherapy, psychotropic drugs, or other similar methods of treatment. So how did this play out in her case? In this case, UNUM approved Ms. McCook's long-term disability benefits, but only for a psychiatric impairment. McCook's treating physicians contacted UNUM and said, look, reconsider this. We think environmentally susceptible patients for years have been misdiagnosed and misclassified as psychologically impaired by doctors who just don't specialize in chemical or environmental sensitivity issues. Unfortunately, her doctors did not sway UNUM's liar-for-hire peer review providers, and UNUM kept on telling McCook that her claim would be denied after 2 years under the mental nervous policy limitations. And in that first 2 years, she continued to receive treatment, including psychotherapy. Now, what happened just prior to the termination of benefits? She supplied UNUM with attending physician statements in which she was diagnosed with toxic encephalopathy, autonomic nervous system dysfunction, and chemical sensitivity based on her failure on a Romberg test and the results of a triple camera SPECT brain scan. Now that sounds objective, doesn't it? Her physicians opined that her anxiety and depression stemmed from the neurotoxicity. UNUM's physician dismissed all of the laboratory testing. They opined that there was no physical evidence to justify a physiological impairment and rejected the results of the brain scan. Of course, her claim was denied, and ultimately she ends up in federal court. In the case of McCook versus UNUM Life, the Louisiana court, using what's called a de novo standard of review, found that she had not met her burden of establishing that she had a physiological or a physical condition. And under the de novo standard of review, the judge can substitute their judgment for that of the disability insurance carrier. Now, the judge found that the evidence provided by Ms. McCook lacked support from the scientific community, as the SPECT test was not a reliable method of examining for toxic exposure. The court acknowledged her argument that there was no better evidence that existed other than the SPECT test to confirm her physiological condition. But the fact that the proper testing doesn't exist doesn't mean that carriers like UNUM have to acknowledge or accept the best testing method available when that method is not scientifically reliable. So in other words, the basis for the diagnosis has to be based on objective testing, which is scientifically reliable and valid. And the federal law is very clear that that is the standard for accepting these kinds of testing. And if you don't have reliable testing results, viable testing results, those that are recognized in the scientific community, it doesn't matter what the testing results are. The court has the ability to reject that evidence, as does the disability carrier. So what are the lessons learned here? The first is that environmental toxicity cases are really tough to win. The second is that a lack of scientifically accepted supporting diagnostic testing can make it difficult to convince even the most sympathetic judge to reverse a denial. And it's clear that carriers will misuse the mental nervous policy limitations to their advantage and to deny claims. Well, that's it for this episode. If you like this podcast, consider liking our page, leaving a review, or sharing it with your friends and family. Remember, our podcast comes out weekly, so tune in next week for another episode of Winning Isn't Easy.